The fact checking unit and its constitutional validity. Kunal Kamra versus Union of India, a case law analysis. First, let us go into the background of the case and its importance. And one may ask why we should bother about this case law. What is its implication on the various freedoms and fundamental rights available to the citizens, including right to expression, right to freedom of trade and business, etc., and other aspects relating to the fundamental rights available to the citizens guaranteed under Article 19 and 21 relating to those aspects. Let us go back to the background of this case, how this case has come. You all know when the entire country was undergoing a devastating disaster of Corona, these rules called intermediary guidelines, digital code, ethics, say they use all the terms rules, code, guidelines. They themselves are not sure what it is. You say either it is rules or code or guidelines. Three are different things, but they gave all the three into the title. This itself is a misleading one, but anyhow, nobody has raised it. Next one, the what is that they wanted to check it? Whether FCU is a new form of censor board, as it is working in the censor board is a board which is working in the Cinematography Act, which is having power to cut down whatever is objectionable to the government in the name of public interest. Now, a similar attempt is made out by the government of India to see that to whatever information it suits their good taste will be made available to the public. Anything which goes against them will not be made available, it will be shut outrightly. How? By threatening this revocation of safe harbor protection. I should explain to you what is safe harbor principle, how it has been embedded. We will do that little later. Now, therefore, this is the rules which have been promulgated during Corona period. Immediately after this, Kunal Kamra, a comedian, see that now he is residing nearby Viluppuram. He is a Bombay-based actor, comedian, satirist. Now he has chosen his residence in Tamil Nadu, shows that at least some amount of liberty, freedom, and peace-loving aspect, law-abiding aspect of Tamilis. That's what I believe would have prompted him to choose this destination when he faces threat in Bombay. Now we will come back to that. Next one, Kunal Kamra is one of the petitioner. Editors Guild, another petitioner. Association of Indian Magazine, another petitioner. The News Broadcasters Digital Media Association, they are another petitioner. There are humpty number of petitioners have approached against the Union of India, Ministry of Electronics and Ministry of Information and Broadcasting. These are the major two respondents. The councils, I think Mr. Sirvai, Mr. Aravind Dattar, I think notable councils who fought for the citizens' right must be appreciated wholeheartedly. We should happily register our thanks through this conversation. Now, the factual matrix, I think I have already told you. Now, what are all these statutory provisions or what constitutional principles it involves? It involves violation of Article 14, violation of Article 19(1)(a), 19(1)(g), 19(2), including Article 19(6). So these are all some of the important principles embedded under the Constitution. Then what are all the statute it is getting violations? It is violating the Information Technology Act, particularly Section 21D, I think, which is defining the term information. Then it is also dealing with Section 69A, Section 79, Section 87. We will tell you what is it dealing with that. But I should tell you, Section 79 is dealing with a principle called Safe Harbor Principle. This principle, which we have borrowed from the United States of America. Please remember, the fundamental rights itself we have borrowed from US. So this is one of the instrument which enables the users of internet to and the intermediaries such as Google, Facebook, YouTube, other platforms to facilitate and enable the citizens to express their ideas without fear or favor, because internet itself is a marketplace of ideas. So how it can survive without legal protection or constitutional guarantee? Safe harbor principle is that any offensive content has been displayed in the social media, then it is not the social media. Say, example, if I am making a defamatory statement against the prime minister, it is not the social media's responsibility, it is my personal responsibility. But once it has been brought to the notice of the social media that I have committed an offense using this platform, right, as an instrument of committing my crime or the crime against state, something like that, then they have to take due diligence principle. If they found really it is offensive, they have to remove it. If they refuse to do so, then they have to incur criminal responsibility. You would have studied something called vicarious responsibility or vicarious responsibility, whatever you call it, under the IPC as well as the new Bharatiya Nyaya Sanghita. Previously, we had this common intention, common object and similar intention, or similar object and common intention. Section 34 to 39, 139, 140, 141 of IPC. I don't remember what is the new corresponding provisions under PNSS. Now, this is called safe harbor principles. As long you are protected, you have taken due diligence, there is no threat of criminal action against the social media. So this is a protection given to them. So when they are losing the protection, when they are warned against these consequences, if they fail to cooperate, then only they lose this protection. But this is an important guarantee. Now, what is this IT rule says about it? The newly promulgated IT rule says any message put out by any person is believed to be, my please note this word, believed to be misleading or false or vague, then the moment it is notified by the FCO, then then the company will shall have to remove the content. Otherwise, they are also liable to be prosecuted under the criminal law as a crime committed by the individual and the social media jointly. This is the principle. Now we will go back to violation of other things. This is around 100 pages. This judgment, I am speaking about the judgment. There are three judges. The division bench was constituted under the chairmanship of uh, Justice G.S. Patel and Dr. Meena Gokhale. They have sharply differed on one another. That's why conflicting judgments. That's why it has been referred to the third judge. That is something called Chandran. I don't remember his name, but we will put out to you in the PPT. The third judge is in clear cut agreement with the first judge. That is Justice G.L. Patel G. Lordship. Okay, now if you read the third judge's judgment, it clearly analyzes both the judgments rendered by two different judges in the division bench, and also says where the third judge is agreeing or disagreeing. Therefore, the judge, once it is getting decided on the majority basis, and the judgment is enforced. The judge now, the after the third judge, the constitutionality of the IT rules 2021 is struck down on the following grounds. A, it is violation of Article 14 because it is discriminatory classification. What is discriminatory classification? I will address you later. B, it is violation of Article 19(1)(a), 19(1)(g), Article 19 Class 2 and Article 19 Class 6. Next, it is also violating the principle called safe harbor principle. It is also violating the judgments given by second judge Meena Gokhale, is violating the doctrine of reading down, chilling effect, etc. Now, what is 14? All of you know, it is giving equality before law. It is permitting classification, but the classification must be reasonable. And whether the classification, what is the classification here? They say fact checking unit will perform the task of auditing the information, certifying whether it is true or false, and this can be done only by the central government. Who can constitute the fact checking unit? Again, it can be done only by the central government, and this protection is available only to the information pertaining to the business of central government. This is where the problem arises. Therefore, this classification is not based on any sound reason or rational or common sense. There is no logic. So you cannot carve out a single person as a class, and that too when you are interested person, you cannot do so. That's why it is called discriminatory classification, arbitrariness. Therefore, it is struck down by both the judges, that is judges G.S. Patel and Chandranji lordships. Next one, how it is violation of Article 19(1)(a). 19(1)(a), you all know, it is a free speech clause, freedom of press. The freedom of press is extendable by virtue of technological development even to the social media. The classic case are the Bengal Cricket Association versus Union of India. This was about the broadcasting rights. During those days, only radio, TV, particularly Doordarshan and All India Radio, has a dominant accessibility and availability to the common public. But the broadcasting rights given to a private channel, whether it is correct or not, its constitutional validity was challenged, because right to freedom of expression can be done only when you are able to receive correct information so as to express your opinion correctly. So the right to receive information has been read into a right to expression of information or freedom or expression, whatever we'll call it. Then now they say government has an interest to give only the true information, correct information and perfect information. To put it differently, they say the right to know include only right to receive perfect information, or right not to receive misleading, vague or false information. This is what the government says. நம்ம தமிழில் சொல்லணும்னா ஆடு நனையுதேன்னு சொல்லி ஓனாய் கவலைப்பட்டதான். இவங்க they want to crush everybody's throat, opposition throat, to voice those whoever is dissenting voice is being totally scuttled, crushed. But they say in the name of preventing of misleading information, we are proclaiming this. This has also been rejected by both the judges. because internet is a place of ideas of market. Reasonable prudent man can judge on his own what is correct, what is incorrect. Therefore, government need not to be an arbiter, and that too nemo sua in sua casa. You cannot be the judge in your own case. This is typically the court has said. Therefore, they said it is struck down these particular rules. Next one, absence of the definition of information. The information given under Section 2 of the IT Act is not covering political opinion, a satirist, etc. Many more things. The government claims it is inclusive. However, they take contradicting stand. The Solicitor General has taken contradictory stand. I will address it little later about the coverage of information. Again, there is no definition what is constituting false, what is constituting vagueness, what is constituting misleading. So, in the absence of this definition, they say this should be struck down. For that, they are relying upon Shreya Singhal case. Exactly, Shreya Singhal has been section 66A has been struck down because of the absence of definition, various terms used under section 66A of IT Act. Next come freedom of trade and business. There are many people like Kunal Kamra. Their business, their profession is to do critique, satirist. They criticize the opinion of the government in the and to bring out right information, enlighten citizenship in this country. Even there are people who do send educational materials. Legal Breeze is also one of such an effort which we are doing it. So we are also talking many things done by the government which is not right or which is wrong. Accordingly, we condemn this and we are creating vigilance among the citizens. This entire profession will be stopped if you are asking that it is subjected to the findings of the fact checking unit. Therefore, they say it is violation of Article 19(1)(g). What is 19(2)? You may ask me. 19(2) prescribe 8 grounds, prohibited grounds. So you cannot exercise your freedom of expression or any other fundamental freedoms listed from 19(1)(a) to 19(1)(g) in violation of Article 19(2). What are the grounds which is prohibiting you to carry out your fundamental rights? Say example, friendly relationship with the foreign countries, public order, decency, morality, contempt of court, defamation, etc. Now, you cannot introduce additional grounds or extra grounds beyond the prescribed 8 grounds under Article 19(2). Whether the guidelines introduces the new ground, yes, it is introducing a new ground called misleading, false, or vague information. This is disjunctive, not conjunctive. Please understand this. This is also another problem. Therefore, government cannot create extra grounds, extra constitutional grounds, either in the form of statute or in the form of rules beyond the prescribed grounds under the constitution. Therefore, since it is creating additional grounds to curb the exercise of fundamental rights available under Article 19, they say it is unconstitutional. Then chilling effect, yes, certainly it creates a chilling effect by introducing threat of losing safe harbor principle. Ramesh Thapur case was relied upon. This is a case law decided by the Supreme Court way back in 1950. That is why our constitution has been amended. The very first amendment introduces additional grounds under Article 19(2). If the central government adds new grounds under Article 19(2), maybe the future laws may be saved, but that is too remote. That's not feasible right now. Then reading down. This is very, very important. The second judge has agreed for this. You all know, no? In Kashmir 370 abolition case, the former Solicitor General, I think now also he is Solicitor General, he has given an undertaking, not even an undertaking, just he has made a oral undertaking before the Supreme Court that we will restore the statehood to the Jammu and Kashmir by September 30th, something like that. Based on that undertaking, they disposed the case without deciding the constitutional validity of stripping the statehood to the Jammu and Kashmir and its consequences. Likewise, he is offering an undertaking that the false, misleading, or vague information will not be used as disjunctively, but it will be read as conjunctively. And also, he says he will exclude the political opinion, criticism, satirism, etc., criticism, etc., outside the purview of IT rules. But this is not given in the form of statute or rules. This is only an assurance given by the law officer of the central government. What authority he has? Based on that, he is asking to read down the words so as to save its constitutional validity. Fortunately, the court has rightly distinguishes the difference between reading down and reading out. This is very important. In fact, you can also see the doctrine of severability. Of course, it has not been discussed here. I can tell you they could have also done, but since it is not severable, since reading down is not feasible, therefore these rules have been struck down on that basis also. So we have covered everything to you in a nutshell. It is violation on the ground of Article 14. It is violation of chilling effect. It cannot be read down. It is there is no definition what constituting vagueness or ambiguous, sorry, misleading, all other things. It is also violation of rule making power. Say there is two things: ultra virus of the Parent Act as well as ultra virus of the Constitution. It is doing both the IT rules, failing, which is violation of the Parent Act, that is the IT Act. It cannot be done under Section 87. It's general rule making power. The IT rules goes beyond the mandate given under the IT Act, and it has never been got to the approval of the Parliament. Again, another constitutional safeguard has been violated, and above all, it is a violation of Article 19 on the all stated grounds.